I am Bill Rochelle, Editor-at-Large of American Bankruptcy Institute, and I am pleased to report that a very important case is now almost on the doorstep of the U.S. Supreme Court. The case has to do with the critical question of enforcing the automatic stay and the discharge injunction, which are at the very core of bankruptcy. Back in April, the Ninth Circuit decided a case called Lorenzen v. Taggart. In that opinion, the appeals court held that a good faith belief you're not violating the discharge is a defense to being held in contempt. But the Ninth Circuit didn't stop there. They went on to say that your belief you're not violating the discharge is a defense even if the belief is unreasonable. Yep, that's right. So in other words, an unreasonable belief that you're not violating the automatic stay is enough to keep you from being held in contempt. Well, of course, a lot of folks thought that decision was wrong, and there was a petition for rehearing and rehearing en banc in the Ninth Circuit. Finally, on September the 7th, the Ninth Circuit denied the rehearing petitions, and counsel for the debtor in that case has told ABI that he will most certainly be filing a petition for certiorari in the Supreme Court. And you don't have to look very far to find a conflict of circuits that should make this case very attractive to the High Court, because in June, the First Circuit, in a case called IRS versus Murphy, ruled very clearly that good faith is not a defense to a violation of the automatic stay. Counsel in the Ninth Circuit case believes that there are many other cases decided in other circuits which give rise to a distinct split of circuits. Well, I'm guessing that the petition for certiorari should be filed sometime in the next few weeks, and I'm guessing that it probably won't be until near the end of the term, perhaps in March, April, or May of 2019, that we will find out whether or not the Supreme Court is going to hear the case. But this is very important because as things now stand in the Ninth Circuit, I think it's virtually impossible to be held in contempt. If you want to read more about these cases and some related cases on the contempt citation issue, please have a look at my column, Rochelle's Daily Wire, on the ABI website. Until this same time next week, this is Bill Rochelle signing off and saying, in the meantime, don't work too hard, enjoy yourself, and make the world safe for debtors.